All rise. Supreme Court of Guam Sound Session. Honorable Robert J. Torres presiding.
Good day and good morning, Council. Sorry, we were a couple minutes late. Will the clerk please call the case?
This is Supreme Court case number CRA21-014, People of Guam Plaintiff Appellee v. Vianney and Hosei, Defendant Appellant. Appearing for Plaintiff Appellee is Attorney Christine Tenorio. Appearing for Defendant Appellant is Attorney F. Randall Cunliffe. The panel consists of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine A. Merriman. Your Honor, Attorney Cunliffe reserves 5 minutes.
You may proceed, Mr. Cunliffe.
Mr. Chief Justice, and may it please the court. The crux of this case, the government's theory is that the victim did not consent to the sexual encounter. More importantly, Your Honors, and in tune with the statute, she did not say no. The indictment originally contained the allegations of mentally defective, mentally incapacitated, and physically helpless. Mentally incapacitated is interesting in our statute because it comes into play if someone gives you something unknowns to you, something that you did not consent to taking that causes you to be mentally incapacitated. Under my reading of the statute, someone who got intentionally intoxicated or intentionally inebriated because of narcotics or some other form could not rely upon these statutes to claim that they were a victim of criminal sexual conduct. The statute in question after this trial was amended by the legislature to include voluntary intoxication under mentally incapacitated. Now, what is physically helpless? Part of the evidence before this court was a videotape where it's clear that the victim is actively participating in this incident. Physically helpless starts off by saying they're unconscious, I believe, or asleep, or otherwise physically helpless. Now, I mulled what otherwise physically helpless could be, because physically relates to the body, not the mind. So I thought, well, how about bound and gagged? You're restrained, you're gagged, you can't speak, but you can still communicate an unwillingness to act by shaking your head, by trying to turn your body to do other things. So that doesn't fall into play. What else is there? Well, is it a doctor gives you a medication that puts you asleep, which you consent to, but now that you're physically helpless, but that comes under unconscious or asleep. So that's nothing new. I couldn't come up with any other scenario that falls under physically helpless other than unconscious, maybe a coma, maybe knocked out. Maybe you drank too much and became unconscious, then it would apply. Maybe you drank too much and fell asleep and it would apply. But if you drank too much on your own and you didn't fall asleep and you're not unconscious, then it's not a crime.
Well, what about the argument that there can be alcohol-induced blackout? And, she had mentioned she had blacked out. So
that's a mental.
While she wasn't necessarily unconscious, she wasn't asleep. She just couldn't remember the incident,
right.
And therefore was unable to withhold consent or to withdraw consent because of the physical condition.
Well, that's not a physical condition, that's a mental condition. You said she blacked out. That's a mental condition. That's not a physical condition. And that's the problem here. That's the government's theory that she couldn't, but she said she was unconscious. So, I'm sorry, she said she couldn't remember. Okay. She could remember a lot of other things. She remembered right after my client got off the bed, she got up naked, went into the bathroom and took a shower. Why did she take a shower if she hadn't just had sex? What was the need for her to take a shower? So the situation is, that's why the legislature, I presume, amended the statute to include under mentally incapacitated that you voluntarily drank too much. And now it's a statutory thing, but it wasn't before. And the legislature wouldn't amend the statute if it already included the elements that are necessary to convict the crime.
In another case that we had, the Regis case, we indicated that there could be a situation where a victim was physically unable to communicate unwillingness to act or unwillingness to enact because of voluntary intoxication.
The Regis case was about the admission of evidence. It wasn't about a jury instruction or the fact of consent, whether the person consented or didn't consent. And in Regis, they were arguing he consented and they were offering certain things to say he didn't consent. But it was as to evidence that was admitted and not to the legal theory of the case that this applied to. So I don't think it's good law for the purpose of this case, because it doesn't directly address the same issue. Now, the government, to bolster their position, vouched for the witness, and only one time, only one statement, but it was their whole legal theory. They didn't say the witness said she doesn't remember. They said she really doesn't remember. If she remembered,
the argument of the government, as stated in their brief, is that this was just a summary of the evidence, and actually even quoted from the transcripts in terms of that's what the SK said in this case,
right,
and during the trial.
but the government didn't preface it. The witness said, da, da, da. They said she really didn't remember.
But this was in closing argument.
It was in closing argument.
And the reference was pretty much a summary of the testimony of the victim here. And so the argument of the government is, it's simply referencing the testimony, and it's not putting the prestige and the credibility of the government behind the statement. At least that's not what the contention was in terms of the government's contention.
The government's theory was that she couldn't remember what happened, and therefore she didn't consent. If she remembered what happened, that theory goes out the window.
Well, I don't know necessarily that follows if she remembers what happened, but at the time it occurred, she was physically helpless, and which is what the main issue in this case. Just because you remember doesn't mean that at the time it occurred, you weren't rendered physically helpless.
But she wasn't physically helpless. She might have been mentally helpless, but she wasn't physically helpless. And they dismissed the mentally defective and the mentally.
I understand. I'm not yet sold that it can't be both, that being helpless affects both mentally and physically. I'm still processing that.
Well,
Conlon.
I mean, if she's physically helpless, how did she walk up the stairs? If she's physically helpless, how did she walk into the bathroom? How did she take a shower? How did she put her clothes back on? How did she walk down the stairs, go home? How did she do all those things?
But it goes to the issue of consent, and that if she was physically helpless and unable to convey an unwillingness to partake in the sexual act, that's what the issue is in reference to physically helpless. And on the issue of consent, which you contend, the court committed error in giving the instruction because it is not helpful to the definition of physically helpless. I'm just not tying that together, because if you do not give your consent, then it furthers, doesn't automatically prove, but it furthers the consideration that the defendant, SK, was physically helpless in this case.
She didn't say no. That's what she has to do. She has to say no.
There needs to be proof of an unwillingness that she was unwilling to partake in the sexual act, or willing. In your case,
She has to be physically helpless so that she is unable to express to communicate her unwillingness. Okay.
correct.
And there's nothing in this case that establishes that she was in that state. As I said, this being too drunk is a mental state, not a physical state. She might have been stumbling, but it's not a physical state. So she had sex with Dwayne. She had sex with Mr. Borja. Mr. Hosei saw both of those acts taking place. She then had sex with him, and then while having sex with him, had sex with Dwayne at the same time. She participated. She didn't say no. How would anybody know that she was not consenting? I mean, how is that communicated to him? She didn't say she couldn't speak. She had conversations with people that night, before and after. If she had said, I remember, and then the next question was, and you didn't say no. You didn't tell him, don't do this. No, I didn't. There was nothing in her testimony that indicated she was opposed to it. I presume she was embarrassed. This thing made it to the internet. Her family saw it. It's not something that you would want anybody to see. And
Well, she testified that she didn't remember, and when a couple of months later, I think was the testimony, someone sent her the videotape. She was shocked, and she didn't realize that those events had occurred. That was her testimony. And now, whether it's up to the jury whether they believed her or not. And at this stage, the deference is in further of the verdict that was rendered in this case.
and in furtherance of the jury's desire or the need to determine whether she's trustworthy or not, the government said she really didn't remember. She really doesn't remember. Laying the weight of the office to the testimony of the witness.
What about Borja's testimony that SK never consented to have sex with any of them, and he believed SK was too drunk to give consent, and he described her as being out of it?
Well, again, under our statute at that time, being too drunk to consent or say no wasn't a crime. That's a mental incapacity. And it has to be, can't be self-induced back at that time.
But isn't it possible that you could still be, in accordance with the definition that's found in 25.10, still be unable to consent because of a physical condition? I mean, that you're being so drunk might not only be just a mental incapacity.
But there's no evidence that she was so drunk that she was, she said she got up right after the incident, walked in, took a shower. I mean,
I
nobody,
think there was a lot of evidence that she was so drunk. I mean, that just the quantity of liquor that she consumed that was testified to have a bottle of vodka. Just the fact that when, she was really dizzy and seemed to be disoriented. I think there was a lot of evidence in the record that, whether, of course, the issue is, whether she was so drunk that she could convey the lack of consent or did not consent. That's for us to decide in this case.
well, in the cases that are cited out of, I think, Michigan, mostly, the people were either asleep or passed out when they said they were physically helpless. She was neither asleep or passed out. And again, as I've cited to the court, the definition of physically as being a manner relating to the body as opposed to the mind. I mean, we're not talking about her mental condition. We're talking about her physical condition. The legislature passed a law 40 some years ago that was written this way. They've now changed it to include voluntary intoxication as a mental condition, not under physically helpless.
Mr. Cunliffe,
Yes, ma'am.
was the defense's theory consent?
Pardon?
Was the defense's theory was that she consented?
No, Your Honor. I believe defense counsel stated that you can't consent if you're physically helpless or mentally incapacitated. In his discussion with the court, I think he said this is just an appellate issue waiting to happen because consent is not an issue. You can't consent.
But didn't he agree to eventually to the jury definition?
He did agree, Your Honor, to allow that. And there were some modifications going back and forth as to what would go in it and what would not go in it. And the majority of it started off with the definition of physically helpless. That being, otherwise physically helpless and unable to communicate an unwillingness to act.
So you're distinguishing that from consent?
Yeah,
'Cause
he did allow it in, and they did discuss it, and they changed some of the things that the government wanted in the instruction. But it's an erroneous instruction.
Would it be harmless error? Did it harm anything?
The whole case was built on consent. Can she consent? That was the whole case. I can't see how it could be harmless.
Well, the government argues that the defendant waived the issue by agreeing the consent, objecting to that there was the jury instruction was an error since the defendant agreed to the instruction that was ultimately given, that there is a waiver issue here and we can't even review it on appeal.
When the defendant agreed, Your Honor, he somewhat acquiesced to the thing, and his position is, and my argument is, of course, that that comes down to plain error. Then, was it plain error to give that, even if he acquiesced to it or agreed to it? I mean, I think years ago, former Judge Abati gave his own instruction for reasonable doubt, and nobody objected to it, and they agreed to it. And the Ninth Circuit overturned it, saying it doesn't meet our standard of reasonable doubt law. And they reversed it on the grounds that it just was an erroneous instruction and conveyed the wrong information to the jury.
The government seems to argue here that because it was an invited error with defense counsel's participation, that precludes appellate review, and it's not because it's a waiver and it's not merely a forfeiture that permits review for plain error.
Your Honor, if defense had brought the jury instruction to the court and said, I want this instruction, it would have been invited error. But the government brought the instruction, they negotiated it, they changed it, they talked about it for quite a length of time before it was coming in. He didn't offer the evidence and the jury instruction, so it wouldn't be invited error.
So if it's a plain error review and we get down to the third element of substantial prejudice, and the government argues that from the testimony, the jury that was presented to the jury, I mean, there was a strong case that she was physically helpless. And of course, you point out the distinctions, the differences. So the substantial harm, I think, again, what is in the plain error analysis, what is the substantial harm that in reference to the other evidence that was introduced that seems to be the government's contention and overwhelming evidence of guilt?
Being overly intoxicated falls under the mentally defective. I'm sorry, mentally incapacitated. I mean, they talk about if somebody gets you drunk, if somebody gives you pills, if somebody loses, and you don't know it, you don't consent, then it applies. So we know that if it's involuntarily, it falls under mentally incapacitated. Why wouldn't it, if it was voluntary, fall under mentally incapacitated? And so they've taken a section that they dismissed, mentally incapacitated, and then they plugged this into it, and they tried to call it physically helpless.
But the mentally incapacitated, it deals with where the substance is given without consent. Right? It's not, doesn't deal with the voluntary issue. When you voluntarily ingest the substance.
But it's the same result. It's just how it got there. The person is mentally incapacitated because they were slipped a date rape drug, or somebody spiked the punch and they didn't realize they were drinking grain alcohol with the punch. And so they became mentally incapacitated, and they therefore were not able to say no. But it's no different. It's just the fact that it was done without your consent versus voluntarily.
And I guess under the B provision of the mental incapacity, the substance is under the influence of the substance to a degree that renders them incapable of consenting. But as you point out, the government eliminated the mental incapacity charge from the indictment when it amended it.
That's correct, Your Honor. Next, the government offered the court and asked the court to read an aiding and abetting statute, which is not Guam statute. Guam statute is with the intention of promoting or assisting in the offense, he induces or aids another. It's a specific intent crime. There's no intent in the instruction that was given in this case. Why they went and decided to have something different than what our law provides for, I don't know, but it's very similar to the case, and I don't know the case name, but it's when Judge Abati made up his own reasonable doubt when it's in the statute. So they created a aiding and abetting that is not our aiding and abetting law, and it misdirected the jury. It didn't give them the requirement that they had to find a specific intent.
Yeah, but part of the government's argument that even if there was a intent element of the aiding and abetting type of provision that is applicable in this case, that again, it was not objected to, subject to a plain error review, and it seemed to have helped your client. There's no substantial harm, and your client was convicted on the second offense of a lesser included offense.
On the second offense than that,
Right.
but not on the first.
Yeah,
I mean,
but
and obviously they're inconsistent verdicts, but the court just don't care whether the verdicts are inconsistent or not, but clearly they're inconsistent.
Well, there were different acts though, right? I mean, so when the jury convicted him of the lesser included offense of CSC 3 on the instructions that were given, they, presumably determined that the prosecutor failed to prove its burden that he was aided or abetted when he was acting in one manner versus in the other. When the sexual intercourse occurred, they felt that he was aided or abetted under the definition. So, even if the definition of aiding and abetting should have included the intent, is it likely that he would have been acquitted but for its omission? So his substantial rights were affected. I mean, that's the question we have to answer.
All right, and as a matter of law, did Mr. Borja's statements, which were generally, and I think almost all of them directed toward Dwayne, not to my client, were they promoting the crime of criminal sexual conduct? Were they assisting the crime of criminal sexual conduct? I mean, if people sit in the stands of a football field and cheer on their team, are they are they aiding and abetting the football team?
But wasn't that for the jury to decide? I
Well,
mean, they both testified at trial. You have their actions, you have their statements on the video.
But
wouldn't it have seemed that the jury was free to judge whether this evidence constituted aiding or abetting?
not when you give them the wrong aiding and abetting instruction. I mean, if you give them the right one, it says he intentionally, with the intention of promoting and assisting.
But wasn't there some testimony from Payelet and Borja about that, or no? About the encouragement or aiding, or you're suggesting that that was just what was contained in the video and there was no separate testimony?
I don't recall off the top of my head if there, I think there was, Your Honor, because initially when we got the transcripts, they were playing the video and then the prosecutor would say, "Who said that?" And you couldn't hear what was said. And so I asked to the transcript to be made complete. So there was some questioning about, and I think that it was always Mr. Borja who was running the commentary. And Mr. Piolet, he didn't do anything except join into the incident. It wasn't anyway assisting or promoting my client. He was promoting himself. Finally, we had addressed the issue of the insufficiency of the evidence. And did the evidence establish that Hosei knew beyond a reasonable doubt that SK was physically unable to communicate an unwillingness to act? He said he did not. As I indicated, he'd seen her have sex with 2 other people that night. He could see her performing oral sex while he was having intercourse with her. He said she looked at him and she moaned. She got up immediately after, went into the bathroom, took a shower. She remembered things that happened before. She remembered things that happened after. She just didn't remember things that happened that were embarrassing to her and humiliating. And they don't meet the standard of being physically incapacitated, physically helpless, Your Honor.
Well, the government in its opposition brief on page 26 and 27 lists a litany of testimony in reference to the sufficiency of the evidence that she was physically helpless. And that seems to provide more than ample evidence that she was physically helpless
Well,
in the case.
Everybody I believe everybody keeps merging mentally incapacitated and physically helpless into the same thing, and they're not. The government did it throughout the trial. The government did it in their briefs, and the government's trying to get you as the Supreme Court to agree with them. And we wholeheartedly do not endorse that position. Otherwise, there's no reason to have the two of them separately, and one is mental and one is physical. And there's nothing physical that prevented her from communicating an unwillingness to act. She was not asleep. She was not in a coma. She was not unconscious.
And it's only in those extreme circumstances that one is physically helpless under your interpretation of that. I mean, you didn't cite any case that would support that interpretation of physical helpless in our jury, in the particular jury instruction or the statute.
Why would the legislature need to amend the statute to include self-induced intoxication and include it in mental incapacity if I'm wrong?
I just think that, it would be helpful if there was some case cited.
Well, there are some
that could
cases
support.
cited which comes out of Michigan, which are not cited for that position, but the cases themselves on physical helplessness were because the person was asleep or unconscious. I found no other cases that called it physically helpless. Thank you.
Chief Justice, may it please the court. This is a case where one male individual, Burton Borja, filmed himself and two other male individuals, Mr. Dwayne Pialet and the defendant in this case, Vianney Hosei, sexually assaulting a 16-year-old female minor while she is passed out due to being extremely intoxicated. At the trial below, right before opening arguments, it is in the transcript that the defendant indicated that he would be proceeding on a theory of consent. The prosecutor below, which was myself, indicated that after the case in chief, I would be amending the indictment to focus on physically helpless for multiple reasons. One, to avoid unanimity issues. Two, because of the state of the law as it was to mentally incapacitated at the time of the trial. So after that, the defense said their theory was that she was never physically helpless because she consented. And that is how consent got injected into this trial. I want to first start with the sufficiency of the evidence of physically helpless because the definition of physically helpless drives the conversation about consent in this case. Now, it is notable that the defense did not brief any arguments as far as what constitutes legal sufficiency of the evidence with regard to the element of physical helplessness. It did not make it to the appellate brief, but if you actually look at the motion for acquittal, which is in the transcript, I actually provided a whole litany of case law where the Michigan courts have stated that physical helplessness can be due to intoxication. And so Mr. Cunliffe's whole argument rests on his position that evidence cannot satisfy both mental incapacitation and physical helplessness, but it's the government's position that we can charge both and the evidence can go to both elements. So they're not mutually exclusive. Now, and the memorandum of points and authorities cited was actually filed in the trial court level for this purpose, for appellate purposes. However, it did not make the supplemental excerpts of record or the brief, but I did orally put that in the transcript that you would find. And what it is that the physical helplessness does not just include a physical condition, as Mr. Cunliffe has been arguing, based on his definition found in the Oxford Dictionary. Physical helplessness is the definition of you are physically unable to communicate a willingness to act, which can include because you are passed out voluntarily from intoxication and overconsumption of alcohol. Now, all of the defense arguments go to the credibility of the witnesses and the weight of the evidence, but this is a highly deferential review on appeal because the fact finder has already determined that the victim was indeed physically helpless. The defendant fails to acknowledge the litany of evidence presented to the jury. They were able to view the video repeatedly. In the video, you can see that the victim's eyes are closed. She's in this body position where she is they can review her body position. She is not responding to any of the male individuals who are talking at her. She had testified earlier that she drank half a bottle of vodka, and the jury could physically see her stature because she was petite. Now, in the video, the filmmaker says, "I feel like a rapist," and they're saying, "Oh no, she wanted this," meaning past tense. She wanted this in the past tense. They're talking to her as if she's not there. They're actually switching her body parts, and she's not responding when they're doing this because that's the government's position, is that she could not physically communicate an unwillingness to act because she was passed out. Now, the boys knew they did something wrong because they all had a conversation afterwards that they felt guilty and that they knew that they did something wrong. And then also during the video, the victim, they're actually being physically assaulting her. One of the males slapped her breast, no reaction. One of the males put his finger inside her genital opening and then put it in her mouth. There's absolutely no reaction from her. So the jury was able to see for themselves and decide whether she was physically unable to communicate an unwillingness to act. And so I disagree with Mr. Cunliffe when he says that a blackout is not a physical condition, it's a mental condition, because based on all the case law that I had cited below, the voluntary intoxication includes both. Now, in this case, you don't, Mr. Cunliffe says that you don't have to say no to manifest you have to say no to manifest your lack of consent. Now, the issue in this is if you're too intoxicated and you're physically helpless, then you cannot consent. Mr. Cunliffe's argument that he presumes the legislature amended the bill because of the consent issue. Well, I don't think presumptions should be had because I actually testified at that legislative hearing, so we would have to go to the legislative intent when looking at that, but I don't think that's on the record, so I will not touch on that today, but the presumption is incorrect. So like the court had ruled in People v. Rages, this court ruled that the conviction was sufficient under both theories of mentally incapacitation and physical helplessness. Under the theory that someone was too drunk to consent, in this case, she was too drunk to consent, but she also was unable to communicate that unwillingness because of her state of intoxication. Now, background on the consent issue. So as stated before, the defense injected the consent issue, and this came up at jury instruction conference because I was the one that told them consent is not a defense, so you cannot argue that here. So I proposed the jury instruction that says consent is not a defense so that the jury didn't get confused, because not only was the instruction given, I think the instruction was necessary because then the jury wouldn't have had a correct state of the law. If we did not include this jury instruction, then the defense attorney could have argued below that consent was a defense in this case, which is not true because, as I think Mr. Cunliffe and I agree, consent is not a defense to physical helplessness, but it's also not a defense to physical or mental incapacitation. The Michigan law is very clear on that consent is not a defense to those two elements. However, if there is a dispute of whether someone is mentally incapacitated or physically helpless, then the consent instruction could be given. But I want to reiterate, the instruction is not consent as a defense. It was actually originally entitled consent is not a defense. And then defense counsel didn't want the title because he said, then you're precluding me from arguing consent at all. So the jury instruction was necessary so the jury could understand the interplay between physical helplessness and consent, because that's not something a layperson would know, that consent was not a defense in this case.
The government is arguing that because the defense counsel had acted the way he did regarding this instruction, that the application of the invited error doctrine it should be administered here.
Right. And so that is the initial argument now, and that's coming from the Eighth Circuit, because Eighth Circuit says that if you expressly agree to the jury instructions, then that is considered invited error. So that's the test for that under the Eighth Circuit.
But in this case, I mean, a lot of those cases looking at invited error seem to suggest there has to be some bad faith on the part of defense counsel in terms of trying to entice the government into agreeing to this instruction or pushing it forward. But it doesn't seem here that that's this type of situation where invited error might be warranted.
Right. So I would say there was no bad faith on the part of the defense counsel below. He actually needed the instruction because that is what allowed him to argue his theory of consent to the jury. So the instruction, the actual instruction that was given, it's actually quoted wrong in the appellee brief, but the actual instruction that was given contained two sentences of the prosecutor's proposed jury instruction, and then the defense counsel was the one that insisted on having it is up to you to decide whether he actually initially said it is up to you to decide whether she consented, but then it was so confusing that we changed it to it is up to you to decide whether she was physically unable to communicate an unwillingness to act.
So I think that the error in the appellee's brief was probably just a typo. It was whereas instead of
whereas. Correct. That was the error. It was just a clerical one. So while the initial argument is that it is waived on appeal, we're still addressing the merits of that argument. So going now to the consent jury instruction, under a plain error standard review, the consent instruction should be upheld without and then this is also like I said before, lay people wouldn't have known what the state of the law is without that jury instruction, and both theories of physical helplessness and mental incapacitation hinge upon the victim's inability to consent. So again, Mr. Cunliffe's arguments, which are devoid of any law, really are inaccurate. We have cited case law in our brief that says otherwise. And I did want to address the point in his one of the briefs where it said that it was improper for the prosecutor to talk about voluntary acts and involuntary acts. And those arguments were made in rebuttal. It was because the defense during their closing argument started to make a similar argument that Mr. Cunliffe was making, that if the victim is physically moving at all in the video, that renders the element of physical helplessness impossible. And so again, based on all the case law that I've cited, it's not just based on your physical ability. Like someone could be moving, but if it's not a voluntary act, then it's not then they are physically helpless. And that the voluntary act that is actually cited in 9 GCA section 4.15. You can't be found guilty of a crime unless you committed a voluntary act. So that's the definition that I was trying to analogize, so that the jury did not have a wrong sense of what the definition of physical helplessness meant. So that is the arguments about the consent jury instruction. I don't think that so one, there was no error because that is the interplay between consent and physical helplessness. Consent is not a defense, and that was merely what the jury was told. Two, if the error was clear or obvious, the error was not clear or obvious, if there was one, because there is no case law currently in this jurisdiction that talks about the definition of physical helplessness and whether or not the consent instruction should or should not be given. So much like in People v. Regis, when we argued that appeal, I think this court came down to the consent, as People v. Wester Wesson, where consent should be given if it is a defense, but in this case, it wasn't a defense. So the error was neither clear nor obvious. There was no error that affected the substantial rights of the defendant because it helped him to do this. And even if the instruction wasn't given, the defense counsel would have made those arguments anyway. That was his whole theory of his case. And you can't preclude a defendant's theory unless it's legally impermissible. So reversal is not necessary in this case because the consent instruction did give the accurate state of the law and the defendant's rights were not affected.
What about the aiding and abetting instruction and I know the government argued that it was parallel after Michigan law, and Michigan law is persuasive, but when I looked, Michigan's aiding and abetting statute is different than Guam's aiding and abetting statute.
So for that one, Your Honor, in that case, so again, the defense did not object and the defendant did not ask for any jury instruction on aiding and abetting below. So this is reviewed for plain error. Now, although the law is not verbatim the same, it is I think the same in intent. So if you look at the
Well, I think
Michigan.
there's a specific intent provision in Guam law that is not found in the Michigan statute.
So I would say in the 4.60. So I think Mr. Cunliffe's argument is that if we should have used the 4.60 definition of aiding and abetting, and the reason why that was not given, and again, there's extensive conversation about this in the jury instruction conference, was that as argued in the brief, that focuses on first party liability, and the actual criminal sexual conduct aiding and abetting as it's written focuses on third party ability, because in the criminal sexual conduct statute, it says aided and abetted by one or more other persons. When we charge 4.60 for aiding and abetting, that is, you have to prove that someone promoted or aided or induced somebody else. So that wouldn't, and that one would have been confusing because these males were not charged with 4.60 separately because 4.60, a version of it, was essentially built into the criminal sexual conduct statute. So, and again, about the intent, the way that the charge was written is that it was.
But why shouldn't the government have to prove the intent of the other person? I mean, that the other, the people that were, in Manila, the Manila case, the Blue House case, I think we determined that one of the owner, Cha, the government failed to prove that she was had the intent to promote or assist in the commission of the act. So and here it doesn't seem like that was required.
My response to that would be, well, even if it wasn't required and specifically stated that the mens rea, that it was proven, because the way the charge is written is that the defendant intentionally engaged in this conduct and was aided or abetted by one or more other people. The jury instruction on the aiding and abetting said just made clear that this aiding and abetting is before or after the commission of the offense, that someone else is I think, promoting or assisting you in committing
It
that
was
conduct.
It was assisted by another person who either did something or gave encouragement.
Correct. And so I would think because the giving of encouragement, to me, that proves intent on the part of the people who are, that's intentionally giving encouragement. You can't recklessly or, negligently give encouragement. In this case, the audio of the video the video was shown multiple times during the course of the trial. And so the jury would have been able to glean from themselves whether or not they're all assisting each other. And this jury instruction was actually given because the defense didn't take issue with the current jury instructions, but it was important that is the only element that was the difference between first-degree criminal sexual conduct and third-degree criminal sexual conduct, which, the exposure to criminal liability as far as sentencing is great between the two. So that's why it was given. And even with the lack of mens rea, it was clear during the closing arguments and really spelled out to the jury that these people are all intentionally helping each other because they're intentionally doing these sex acts to this girl who's passed out. And I went through each of the pieces of audio that were there to prove how they are all helping each other. And the jury, I think, did give credence to that jury instruction, actually, because then, as noted, he was found not guilty of one of the acts, meaning they found that he was not aided or abetted by someone or the boys during the commission of the second act. So I think under a plain error standard of review, his rights were not affected and he was not harmed because whatever jury instruction that was given was actually, it led to an acquittal on the first degree criminal sexual conduct of one of the counts.
Well, what about the argument of Mr. Cunliffe that may have been the case with the second offense that where the lesser included offense was found, but what about as to the first CSC count?
So for the first CNC, again, the way that the jury instruction is written, I think it spells out to the jury that we had to prove that these boys are consciously helping each other commit these offenses. And so that was how it was argued to the jury, that this is all intentional conduct on the part of all of these boys, especially because each of them were charged with intentionally engaging in the sexual penetration. And the jurors were told that the two other boys who were not on trial did plead guilty to the intentional engaging of the sexual penetration. So they had all of that evidence before them as far as everybody's acts. We had to prove that they were intentional and they did plead guilty. And then we used that to prove that this defendant, Hosei, did intentionally engage in those acts and was aided and abetted by the other individuals. And if 4.60 had been given, though, it would have had to be a part of the indictment because we would have had to specify the crime committed. Because when we charge 4.60, you have to actually spell out the crimes that are committed. So we didn't want to confuse the jury as far as giving them two separate things to look at when the aiding or abetting is clearly embedded into the criminal sexual conduct statute. Now, so if this court that finds that there was error, the error was neither clear nor obvious because, again, that's not the aiding and abetting element of the criminal sexual conduct statute has never been appealed to this court. So there would have been no body of case law addressing.
What about the contention of the Chief Justice that People v. Manila seem to have specified that, there is an intent element requirement in the aiding and abetting statute?
Right, so that would be intent requirement to the aiding and abetting as
The
far
third
as
person type of aiding and abetting, and not that the defendant himself was aiding and abetting someone.
so I would distinguish on that basis, I would distinguish the facts from the Manila and Cha case from this case, because this is a case where all boys are actually themselves engaging in the sexual conduct, which is an element of the first degree criminal sexual conduct. And I think in Cha or Manila, that was aiding and abetting the drug or sex trafficking. So I would say
but it's the same scenario in terms of Mrs. Cha was it had to have been proven. And in that case, the government felt to proven that, therefore, that offense was not firm, but it had to have been proven that Mrs. Cha aided and abetted, knowing that the victim that was provided there was going to assist in the carrying out of the sexual act.
Right. So if the court does think that does decide that it was clear or obvious under the People v. Cha, then I would just go to the next prong, which is whether your substantial rights were harmed or affected. And again, then I would loop back to my argument that we had charged all of these individuals with intentional conduct in engaging in these sexual acts. And then during closing arguments, we went through what each actor did. And because Mr. Cunliffe in his brief says it doesn't matter what the other individuals did as far as the element of knows or has reason to know that a victim is physically helpless. But in this case, it did matter because those circumstances of putting forth the evidence pertaining to Dwayne Pialet and Burton Borja showed that Mr. Hosei knew or should have known that she was physically helpless. So their conduct was actually a part of the evidence. And so even if the jury wasn't instructed that they had to intentionally aid and abet, like I said, the jury knew that we proved that they intentionally all engaged in this conduct
But could
separately.
there have been some confusion if there was a specific jury instruction of the intent element that all the government had to prove, or that the government proved that it was the defendant who was the one that aided and abetted? Could there have been that confusion without that clarifying jury instruction? In other words, it was the other way of aiding and abetting, not the third person aiding and abetting.
Right. And I think that is a point of confusion, which is why that was not done, because the way the charge of the indictment was worded is that you were aided and abetted by one or more other persons, not that you aided and abetted them. But the difficulty in that is all the two other co-defendants pled guilty to third-degree criminal sexual conduct, which was not aiding and abetting. But the thing is, they themselves were charged with the fact that defendant Hosei aided and abetted them, because then defendant Hosei ended up as the one or more other persons aiding and abetting. But because those two were not on trial for aiding and abetting, because they had pled guilty to third-degree criminal sexual conduct by force or coercion, the jury didn't hear that part, but they did hear about the intentional engagement of the acts of all of these people. And if you actually hear the audio of the video, the audio shows that they actually are all helping each other. And I don't think that a jury could have construed, this is going to the sufficiency of the evidence really on aiding or abetting, I don't think the jury could have construed all of their discussions during the video as being reckless or negligent or knowing, because they are all saying, move her legs, do this to her, put this on her bed, don't do that. And they're all assenting. And the evidence that was listed confirmed who is saying what parts of the audio when they're doing that, and who is actually touching her at all these different points.
So your argument then is that evidence satisfies two mens rea requirement under the way it was charged. Number one, the defendant intentionally committed these sexual acts, and then was aided and abetted by a third person who intended to assist
Right.
in helping carrying out. And so you're saying that the simple fact that we were able to prove that there was a intent to violate, to commit the sexual act, that satisfied both intentional element of the crime as charged under CSC 1.
Yes, that coupled with the evidence that came out of trial, how that intentional engagement of the act was all of them having a discussion about basically assisting each other on what's going on the camera.
But the fact that the jury instruction on the aiding and abetting with the intent element was not provided, did that cause any confusion that simply proving the intent element on the part of the defendant to commit the act was sufficient to satisfy the dual intent element that is required under the crime as charged.
So like I said, I don't think there could have been any confusion, and I don't think that any confusion was caused because we repeatedly stressed that all these boys had engaged in this intentional conduct and they were all doing it in concert with each other. And the way that it was even posed by the defense counsel below was group sex. They kept saying like that, group sex. And so the jury kept hearing that. And if you hear that kind of verbiage, then there is really no, I would argue, no question in anyone's mind that all of them were intentionally aiding and abetting each other because it was a group sex, even by the defense counsel's
So if that
characterization.
theory is correct, that the evidence that was presented showed the intention to aid and abet. What about how that plays that the defendant himself had to have intended to commit the sexual act, and that the victim, SK here, was an unwilling participant. And so if the separate proof required that he intended to commit the act and that she was physically helpless and an unwilling participant, shouldn't that have been specifically laid out? I guess my little confusion here is you say the fact that we were able to show that, you know, they are all helped each other, and that which goes to the aiding and abetting also satisfies that the defendant intended to commit the violation, knowing that she has not consented.
Right. So the defendant's intention in engaging in the sexual penetration was made very clear because I actually broke down each element for the jurors and explained how the evidence went to each element, including that he himself intentionally engaged in that conduct, and then later how he was abetted by one or more of both other boys by going through what each of them had done in the video.
I guess there's no question that the defendant intentionally committed the act. I think that is the evidence bears that out. And then I guess how it relates, whether that mens rea is vitiated, well, maybe that's not the correct term, in reference to her consenting, as argued by Mr. Cunliffe, that she was seemingly a willing participant. I don't know if there's a question there.
Right. And so I don't know that there's a question, but I would reiterate that the testimony by the two other co-defendants were that they both either thought she was too drunk to consent or she was out of it or something to that effect, which would go to that element. So just in conclusion on the other elements, again, if this court doesn't consider the vouching waived, the single statement that she really doesn't remember, that was a direct quote from her saying, I really don't remember, and summation of the evidence, but also throughout closing and rebuttal, the prosecutor repeatedly told the jurors that it was for them to decide this whole situation, whether she was blacked out drunk or whether she was lying, and repeatedly said it was for them to decide, which would moot any contention of vouching. Thank you.
Thank you, Ms. Tenorio. And welcome back to our courtroom. Mr. Cunliffe.
Thank you, Chief Justice. The government argued several times that the SK was passed out. I don't think there was any evidence of that. Unless she just fortuitously became conscious again as soon as the act was finished and got up and went into the bathroom. She actively participated in giving oral sex to Mr. Pialet. She did have her eyes closed. Did Mr. Hosei have his eyes closed? The camera wasn't on his face. I don't know. We don't know. But she said he didn't respond. Her eyes were closed, but she did respond. She responded quite graphically in the video when Mr. Piolette's penis came out of her mouth and she grabbed it and put it back in. So I can't say that I don't think anybody can say that she had passed out and she was unconscious.
How about SK's own testimony that she lacked any memory of the incident?
Well, I mean, she can lack a memory of it. That's a mental problem. Again, but she and the jury can believe her or disbelieve her. But whether she doesn't remember it, you can see her participation. I mean, she wasn't unconscious. The aiding and abetting, the instruction was given was, giving encouragement. Well, that's not the statute that we have. The government says, well, we didn't want to charge 460. They don't have to charge 460, but under the statute that they chose to charge, aiding and abetting is an element, and they chose an element, a jury instruction that did not provide the correct elements within our law. And the government goes on to state, well, there couldn't be any confusion. Well, as Your Honor pointed out, they found him not guilty of that charge in one of the counts. So what do you mean there couldn't be any confusion? I mean, they're obviously, they came up to two different conclusions. One that he aided and abetted and one that he didn't. So or he was aided and abetted and one that he wasn't aided and abetted. So to say there's no confusion begs the argument that what it shows but happened in the jury deliberation and what the verdict came out. So the situation is such, Your Honor, that we believe that the court must reverse the convictions for Mr. Hosei. Thank you, Your Honor.
Mr. Cunliffe,
Yes, ma'am.
what relief are you requesting?
I'm sorry.
Are you requesting a new trial or?
Yes, based upon the erroneous jury instructions, then he didn't get a fair trial and he would be entitled to a new trial.
All right, thank you, Mr. Cunliffe. Thank you.
If it may please the court, this is probably my last oral argument before this court. I want to thank you.
Thank you, Mr. Cunliffe. You've been a valued practitioner before this court, and we appreciate your contributions.
You may still get appointed, so I wouldn't take that to the bank.
All right, the court will take the matter under advisement, issue a written opinion, and will now stand adjourned.